All rise. The District State of Florida is in session. Now, Richard T. Orfinger, Judge, presiding. You shall be heard. United States of America, State of Florida, and this
Good morning and welcome to an oral argument session at the 5th District Court of Appeal. As the Marshal indicated, I'm Judge Orfinger, and I'm joined on the panel today by Judge Jacqueline Griffin, and we have an associate judge from the 18th Circuit, Judge Robert Berger. It's always a pleasure to have associate judges with us. If you have a cell phone or a pager, we'd appreciate it if you would silence it so that the parties aren't interrupted. We have 3 civil matters today, so the parties have 20 minutes per side, and the appellant may reserve some time, and if you'd like to tell me what you want to reserve, we'll set it on the clock for you and try to alert you.
Thank you, Your Honor.
Other than that, I think we're ready to proceed with U.S. Bank versus BJELJAC.
Thank you, Your Honor. Good morning, and may it please the Court. Jack Ryder on behalf of U.S. Bank. I'd like to reserve 5 minutes for rebuttal, Your Honor, although I don't anticipate that the argument will take that long. With due respect to the trial court here, Your Honor, it is clear that the trial court abused and grossly abused its discretion in first denying a motion to cancel and reset a sale, foreclosure sale, then denying an objection and to vacate that sale filed the very next day following the sale, and then a motion for...
Let's talk about where the thing goes off the tracks, which is where the trial judge, after 5 on the day before the sale, your office faxes up a motion to cancel, which the trial judge denies the next morning.
Yes, Your Honor.
I read that motion. It is not a model of pleading. In fact, I would say that in that respect, I probably join in the trial judge in his conclusion that no lawyer ever actually looked at that. All it says is, cancel the sale and reset it.
Understood, Your Honor.
Tell me how, when you give the trial judge nothing, I mean, we've reversed that same trial judge a number of times when the parties have said, we've got a workout, we've got something going on, we're trying to save this guy's home. You don't give him anything other than cancel the sale.
Understood, Your Honor, and I'll address that in 2 ways. Number one, that motion was in fact identical, and I understand Your Honor's perspective that it was a very brief motion. It didn't identify various bases. However, it was identical to a motion that the same trial judge granted previously.
That
so
may
he
be,
did grant
but
this.
If I'm looking at that motion as a trial judge and I say, the rules require that you plead your grounds, that doesn't, it asks for action, but it doesn't state any grounds for doing it. So the fact that he may have granted an earlier motion doesn't show me much. Now, that may speak to your issue of should you have relied, or was it a mistake to assume that the judge would do it? That may speak to that. But help me understand why that was even a legally sufficient pleading at all.
Well, Your Honor, I would suggest that, and I agree with Your Honor first, that's the observation that we really rely upon that to show the existence of a mistake. In fact, again, our appeal is not just from the denial of the motion to vacate, the motion to reset and cancel, but the subsequent motion that did identify the fact that the parties were attempting to amicably resolve the situation. So I agree that with Your Honor that the motion could have been better. But it did, in fact...
In fact, it couldn't have been much worse.
Well, understood, Your Honor. And of course, and I don't make excuses for the fact that the motion was not a model pleading or a model motion. However, it did specifically request what is, in fact, a fairly routine practice. For better or worse, this same judge had granted an identical motion previously. The parties were relying upon the fact that the final judgment did say that the sale would not proceed absent if the seller was not there, the lender was not there.
Now, I have a very hard time with that argument, primarily because, you know the pleadings in the case, you know the papers.
Yes, sir.
The final judgment did say that. The first order resetting the case said the sale won't be canceled absent a specific order from the court.
That's
now,
right.
I don't see any way in the world that you could rely in good faith or even assume that the provision that was in the original judgment was unaltered by that subsequent order.
Well, here's how, Your Honor. First of all, I would respectfully suggest that the fact that the subsequent order said that the sale would not be canceled absent court order did not negate the fact that the plaintiff would still need to be present. It simply said an order would have to be issued to cancel the sale. And also, and I did want to point this out, it didn't say that the sale would only be canceled upon a showing of good cause. It didn't say the sale will only be canceled for a reason. It said the sale will only be canceled by court order. And I believe, based upon the history and the record of this case, that the plaintiff operated under a mistaken belief that it was a ministerial act, and that just as the prior motion had been granted, so too with this one. I think that the plaintiff, again, you know...
But you concede that it's, in fact, not a ministerial act, but a discretionary act.
Your Honor, I agree with that. However, the statute, Section 4.5...
You're arguing abuse of discretion.
Yes, Your Honor, but not only as to the failure to reset and cancel the sale, but also as to the failure to vacate the sale based upon objections filed the very next day. And perhaps it would be best if I did turn to that, because to the extent that the court, if the court does not agree that the court abused its discretion in not resetting and canceling the sale, clearly the court abused its discretion in not vacating the sale pursuant to the objections timely filed the day after the sale, which did in fact identify the fact that the parties were attempting to amicably resolve the situation between the borrower and the lender.
Is the mistake in denying it, or is the mistake, as you see it, in not affording you a hearing so you could at least put on a showing? I mean, you understand the two-prong test, and they've conceded prong number one.
Yes.
So do you think that the mistake by the trial court was in not just doing it, granting your motion, or do you think the mistake was in doing it without affording you a hearing to demonstrate mistake, neglect, fraud, you know, the various parts of the test?
Your Honor, based upon the history here, I would respectfully suggest that the trial court should have vacated that sale and should have granted the supplemental objection. And I do believe that at best, or at worst, the court should have at least conducted some sort of inquiry, but as the court, of course, was aware, the judge just rubber-stamped it with denied 3 times, 3 different orders, all 3 different motions, requests for relief, all rubber-stamped. When this court relinquished jurisdiction and asked the trial judge to explain his basis, his discretion, the judge did not specifically identify, in my opinion, with due respect to the trial judge did not identify a specific basis why he exercised his discretion. He said that in his opinion, the motion on its face did not give him sufficient grounds. Well, number one, and going back, first of all, to the original motion to reset the sale, again, it was in fact identical to one that the trial judge had granted. More importantly, the supplemental objection specifically did state that the parties were attempting to amicably resolve the situation, as did our motion for a hearing, which was also a supplemental objection that did in fact expand upon the fact that the parties had been attempting to amicably resolve the situation. So just as this court very recently did in fact reverse this judge in the Lipica case, and specifically noted that the parties were not under an obligation to actually attach copies of the documents, but the representation of counsel that the parties were attempting to work out some sort of settlement was in fact sufficient. This court reversed and found that this same judge did in fact abuse his discretion in not granting the relief when in very similar circumstances, even historically in Lipica, the court first rubber-stamped the denial. This court said that's not good enough. The judge has to identify the basis for his discretion. In that case, the judge, I believe, attempted to identify even a greater level of explanation than in this case, and in this court still reversed and found that it was not a sufficient basis for denying the relief. Because as this court stated, and again, consistent with multiple cases we've cited, consistent with Florida law, the purpose of a foreclosure proceeding is, of course, equitable. And here, when we did, in fact, identify a basis, the basis being that the parties were attempting to amicably resolve the situation, this court held that settlement being obviously a worthwhile endeavor, that the trial judge abused and in fact grossly abused his discretion in not accepting the representation of the counsel as an officer of the court, and in this case it was set forth in the subsequent motion to vacate the sale and in the motion for hearing, which was also styled as supplemental objections within the 10-day period pursuant to the statute of the sale. The trial court could have reviewed that, accepted the representation, and should have accepted the representation that there was a basis, a reason why U.S. Bank sought to reset the sale, and granted the relief.
Of course, there is a procedural difference with a Lipica case or Lupica case, and that is that there wasn't a third-party purchaser that was involved who, you know, I would assume has some due process rights. And that's the reason I say that if you're entitled to some relief on the basis of essentially mistake or mistaken reliance on the fact that you thought the judge would grant this, doesn't that become a factual dispute that, in this case, because there are third parties involved, which wasn't the case in Lupica, that was just really an unopposed motion. This is opposed. Doesn't it become a factual matter for you to now go back to the trial court and demonstrate a mistake?
Your Honor, I believe that is a distinction with Lupica. However, I think it's important to note that when we talk about a third-party bidder, we have to, I believe, from the perspective of equity, look at the third-party bidder in this instance, which we know, again, it's the same third-party bidder in another case that this court recently remanded for further addressing, for the lower court to address further. This is not a third-party innocent bidder, in my opinion, who came along and purchased the property for fair market value. We've got an individual, or excuse me, a corporate entity that purchased property for 5% of the value of the judgment. Now, again, not to cast aspersions on the...
Hold on. That number is really irrelevant, isn't it? The number...
Well, they've conceded it's grossly inadequate.
No,
so.
hold on. But you argue at length that it's 5% of the judgment. Isn't the relevant number fair market value of the property?
It is, Your Honor. However...
So the fact that it's 5% of the judgment informs us in no respect, and it's, in my mind, completely irrelevant.
Here's the relevance, Your Honor. The BJELJACs are now going to be subject to an extraordinarily large deficiency judgment. And that number, the $275,000 mortgage, is the amount that they are still responsible for.
But the gross inadequacy measure is measured against the fair market value of the property.
Which they've conceded, Your Honor.
I'm not fighting with you. You're the one that brought it up, and you said, you know, it was 5% of the judgment, and I'm just saying that's true, but that's irrelevant.
And Your Honor, from the perspective of equity, I don't believe it's irrelevant. In Roberts versus Kislak, the 4th District held that equity should be resolved in favor of the property owner and against the bidder who acquired realty for a paltry bid and exposed the borrowers to liability for a deficiency judgment. Quote, rules and procedures, while important, should not receive priority over substance and manifest injustice, unquote. Here, we have a bidder who came in, purchased the property for $16,000, and we have a $275,000 outstanding mortgage. Now, in the 4th District, they specifically looked at that issue, and they looked at a circumstance where they said, if there are doubts, the doubts should be resolved in favor of the innocent, so to speak, the defendant in this case. I call them innocent because obviously they're the ones, in this instance, who, according to the filed documents, U.S. Bank was attempting to amicably resolve the circumstances, and they're the ones who are now being faced with a huge deficiency. And to that extent, Your Honor, I suggest that the $275,000 number and the fact that the amount paid is relevant. With respect, though, to the gross inadequacy, it has been conceded, and that does go to the value of the property itself. But I think from the perspective of equity, as a foreclosure proceeding is, at the end of the day, what we have here are property owners, no longer property owners, who are now facing this enormous deficiency. So you have U.S. Bank that lost the value of its collateral and did not get paid the fair market value of the property. You've got the borrowers who are now subject to this enormous deficiency judgment, and you've got the third party who has enjoyed an enormous windfall by obtaining property that they acknowledge was for a grossly inadequate bid. So from the perspective of doing equity and the perspective of the ultimate result, I would respectfully suggest that, at best, yes, there should have, I believe that this court can reverse and remand with directions to vacate the sale.
Well, that's my problem. I'm not a court of equity. I'm a court of error. and I have to determine whether the trial court reversibly erred. And I'm faced with an argument that as a matter of law, after a sale goes forward, after the sale goes forward and a motion is filed asking to set aside the sale on the basis that the parties are attempting to work something out, and I get an order from the trial court that says, look, the case has been pending for 523 days, and at the last minute I get a motion that gives me no reasons, I denied it, I don't think I did anything wrong, denied. And my problem is how I can say that the trial judge reversibly erred in doing that.
Because the trial judge, Your Honor, was required to do equity. And I would also suggest to the court that, yes, while this is a court to examine error, I don't believe that that distances the fact that at the end of the day, equity is still the ultimate goal. Even though this court is limited from the perspective of whether error occurred, this court can also examine whether the lower court did in fact advance equity. And that's the perspective I believe in looking at this situation, where this court can say the lower court erred because it did not advance equity. Not simply whether or not it stands before this court from the perspective of equitable considerations or not, thank you, Your Honor, but from the perspective of the fact that the lower court did not advance equity. And that was what the lower court was required to do. And I see that I'm at my 5-minute point.
So so essentially your argument is that if the trial court gets a motion that says we're trying to work it out, cancel the sale, he's got no choice.
Your Honor, if the goal is to maximize settlements and resolution, I would suggest that a court abuses his discretion by denying a motion like that. Yes, Your Honor. Thank you.
So, Reader, just to kind of follow up on that, I think that would cut a much wider trench, at least than I'm willing to go. It seems to me that if you have some basis for relief, it's the idea. I mean, I think that the motion that was filed stated no grounds, and I frankly have a hard time saying that the trial judge erred when you gave him nothing. I mean, there was nothing there. Now, I do think that perhaps you would be entitled to a hearing on your motion to vacate to demonstrate whether or not this is a mistake in the sense that, I think, what is it, A-R-L-T,
Yes.
or however that's pronounced, speaks of. So, but we'll see.
Then we would request, of course, Your Honor, remand for a hearing in order to explore that issue.
Right.
I think that would certainly
let's see
be...
what Mr. Paul has to say about this.
Thank you.
Good morning, Your Honors. I'm Harlan Paul with the law firm of Paul & Elkind on behalf of the third-party bidder, Appellee. The first thing I want to do is just address the one point about the judge having approved or granted the prior motion that was identical, and that formed the basis of reliance that this motion would be canceled, the sale would be canceled. That motion was filed more than a month before the sale. The judge, in his subsequent order, specifically found that the sale was canceled not because of any order of his. It was mysteriously canceled by some other person. I don't know if it was the clerk, the plaintiff, or who it was, but there was no order of the court canceling that sale. His order came after the sale was to be held, and what he says in his order, which you have before you, is that there was no notice of any kind of the cancellation, and he was granting the resetting of the sale. He didn't grant the cancellation of the sale, which had already occurred, or not already occurred, the time had already passed for it. The sale did not occur by the time he entered his order.
Presumably, and I'm just, again, kind of reading between the lines, I'm assuming that the sale didn't happen because the plaintiff didn't appear, and the judgment said if the plaintiff's not there, don't conduct the sale. So it wasn't necessary. I don't agree with that sort of an order, and apparently the Supreme Court doesn't either under their new rules. But, in any event, that's what it said, and so it wasn't necessary to have an order canceling. So really, I agree that what he did was he reset the sale. He didn't ever cancel the first one.
Right, and he didn't...
But let me ask you, what bothers me about the case is the fact that, not that Judge Doyle denied the motion to cancel the sale, because there was nothing there. There just wasn't anything upon which he could make a reasoned... they didn't even throw in, we're trying to work it out. It was just cancel it and reset it. But they did file a well thought through motion to vacate the sale the next day, and they set forth all of the grounds, and you concede on one of the two prongs, and so tell me why that they're not at least entitled to a hearing on the issue of mistake and fraud. There's no fraud here and that sort of thing, but the mistake part, that's really what they're relying on. Aren't they entitled to a hearing on that?
Let me address your comments, your question, but before that, the comments you made about the grossly inadequate price. We have conceded the gross inadequacy or the inadequacy of the price, whether gross is an issue or not. It actually is 16% of the market value based on the tax assessment. So when you're talking about the judgment amount, I want to clarify that. Well, we've conceded that, so that's not really an issue. In answer to your question, what you call a well-pleaded motion that was subsequently filed by an attorney this time.
It was probably the motion for rehearing that was
right.
Probably the more well-thought-through motion.
What it actually says is that the parties are attempting to amicably settle. What does that mean? And I know, if we had had a hearing, maybe we'd be able to show that there really was no discussions, because in this case, the defendant, who I presume is an appellee here, although he's never been defaulted, never filed an appearance, never appeared before the court, never filed any motion of any kind. There's not even an affidavit of this particular borrower, as there is in the other cases that this court has reversed, indicating that there was some basis for either a short sale or negotiations of a forbearance agreement. So I think even then the court had nothing. That, before they had, I think, an obligation to advise the court, what is it that we should hold a hearing on? Well, give me some basis for finding that a hearing would be even purposeful.
Do you think any of those concerns are alleviated in their motion for rehearing following their motion to vacate, the denial of the motion to vacate?
Well,
and I guess it's no secret to you, you've been involved in a couple of the cases and you've read the rest of them, that we're not enthusiastic about the rubber stamp treatment. It doesn't give us much confidence that when judges have discretion, that they have exercised much thoughtful consideration.
Yeah, I think I am aware of this court's rulings. In fact, I just argued the trial level one that was remanded, and I can tell you the trial courts are of the opinion that they should just automatically cancel sale for any purpose, for any reason whatsoever. So yeah, I'm aware of that, unfortunately. But in this case, I think the distinction again is that what you referred to as the well-pleaded motion for rehearing, you may have it committed to memory better than I do, but I don't think they give any real legal grounds.
Maybe I was being generous given my earlier treatment of the original motion.
In comparison, it is well pled. And I don't need to cite to the court, I don't want to not at least mention that obviously Rule 1.100B, which you're referring to, which says must be specifically pled, but even the comments to the rule says a motion must specify with particularity the grounds upon which the motion is based and set forth the relief or order sought. These requirements are mandatory.
But what about the motion for rehearing? By that time it seems like they figured out, we've kind of let the train get off the tracks here, and we need to pull it back onto the tracks.
Yeah, I look at that kind of like a motion to set aside a default. Do you have...
Well, there's no question they're asking for a mulligan.
Yeah.
But isn't that at least meritorious of a hearing to determine if they should get a mulligan?
I think if they had properly pled that there was some basis for it, yes. I would then say you should have the hearing. But in this case, even when they were faced with possibility that this sale would go through and not be set aside, knowing what the judge was likely to do, they still gave no legal basis for the court to even have a hearing to consider those issues. Just saying that we're trying to work things out. So I don't know that a hearing in that case, I don't believe a hearing in that case is required, but it's
Well, but isn't the issue not so much whether or not there was a legal basis, but if they honestly, if the trial judge concluded that they honestly but mistakenly thought that their sale would get canceled and didn't show up. I mean, you know as well as I do that if they had come to the sale, they could have just bid up to the judgment, and they would have at least ended up with a property. So isn't that what we have to focus on? Not so much that they didn't give you a whole lot on the settlement negotiations, but the focus here is on, did we make a mistake in not showing up? And isn't that the second part of the test that we have to look at?
Did they make a mistake? No, I think they made a calculated decision. Was it a mistake under ALT? No, I don't think it was a mistake. I think what they did was assumed, if that's a mistake, that they could file a motion knowing the judge may not even be present the next morning. If the judge hadn't been there, there would have been no order entered, and the sale would have gone forward. So when they do it...
No, I agree, and I suspect that if they could do it all over again, this is not the way that they would do it.
They didn't call the court, didn't call the clerk. So I think in not appearing, I think that there was absolutely no basis for just assuming. I don't think it's a mistake. I think it was a calculated decision.
Well, but I think, that's really the basis of my question. Doesn't that become a factual issue to determine whether that was a mistake or a calculated strategy or a practice? We do this all the time, and, this is just the way we do business. I mean, one man's mistake is another man's strategy, and that's why I'm just wondering if that's not a matter for...
Yeah, I can't really address that without arguing things outside the record, which I'm not going to do. All I'd say is that I think the court did the right thing with what it had before it, and not setting a hearing. The only thing I want to address before I finish is that a few things, but I may not have the time to. One is the issue of equity. This court's fully aware that the borrower is not what I would call on the hook, is not responsible for the balance of the judgment until there's a deficiency judgment entered. A deficiency judgment is based on the market value of the property, the fair market value of the property as of the date of sale, which requires expert testimony. So to argue that a borrower who really has no interest in these proceedings whatsoever is damaged and has this judgment out there, I'm not going to call it, I'm trying to think of the proper word, not disingenuous, but is not really an appropriate argument, because they get the benefit of the value of the property, regardless of the sale price. And but for the fact that if this court were to remand, but for that fact, I think to grant the relief request, it really would be to make a sale a ministerial act. You just don't show up, and I forgot, or I'd intentionally not show up, and it would become more of a ministerial act. Let me just look over my notes. I think I'm about done. I think the court has already distinguished the two recent decisions of this court, Wells Fargo versus Lupicia and LaSalle versus Alicia. In those cases, there were clearly grounds that there was a mistake that was alleged in all the motions, and they were denied without hearings, but they were specifically provided for. And this Supreme Court, the Florida Supreme Court, has recently come up with a form motion which specifically lists an abundance of grounds that could be listed which weren't here. In that case, there was both forbearance agreements and they'd enter into the HAMP program to redo their mortgages. That's all I have, unless there are any other questions.
Thank you very much.
Thank you.
I think first it's important to note that courts have held that any mistake, even a unilateral mistake, is sufficient to constitute the type of irregularity to satisfy the ALT criteria for setting aside a sale. Here, And I think, Your Honor, we heard the notion of, well, any mistake would be sufficient. The bottom line is, any mistake is sufficient. This talk of a calculated decision, I think as I heard the argument, I understand the court's concern about whether or not there really should be a hearing to let the parties discuss this. But at the same time, and I think at worst, this court should reverse and remand for a hearing on the issue, but at best it should reverse and remand with directions to vacate the sale here for several reasons. First of all, the concept, this wasn't a situation where U.S. Bank simply just didn't go. And even simply not going, in certain cases, has been sufficient. In the case of Fernandez versus Suburban Coastal, the 4th District said a failure to attend a sale was a sufficient mistake to warrant setting aside the foreclosure sale when there was a calendar entry that was wrong on a person who was hired to go attend the sale. This wasn't a case where U.S. Bank just didn't go. U.S. Bank filed something. And again, I understand the court's concern and the court's observation that the something was not a written motion that was filed prior to the sale, but it was something that said, we understand that there's a sale tomorrow and we're asking the court to cancel and reset it. So I think that it's unfair to call this a calculated strategic decision. It was in fact something that was filed with the court, presented, requesting that the sale be canceled. If the reliance upon that, because it was poorly pled or poorly written, is a mistake, it is sufficient to constitute grounds for vacating the sale, particularly in light of...
What do you say about, Mr. Paul points out, and from what I can remember of the record accurately, that the trial court had not granted an identical motion. There was no motion to cancel the earlier sale and reset it. The final judgment originally said if we don't show up, it won't be conducted. Apparently you didn't show up. So the first motion that the trial court granted was just, we need to reset the sale.
I believe, Your Honor, that, and I'll grab it right here, but I believe it actually said cancel and reset. I believe it did in fact have those same words.
It had already been canceled. I mean, it hadn't been conducted.
Well, but there was, Your Honor, there were 2 prior motions where in fact the judge had specifically granted the relief and the court entered the order. Now the court made the notation that there was some lack of clarity in the record as to how an earlier sale had been canceled, but the judge had previously granted a motion to cancel and vacate the sale, or excuse me, reset the sale.
I'll go back and look. I mean, the record.
And I apologize, I don't have the dates, the chronology directly in front of me, but the last thing I want to point out before I close today, Your Honor, is that if we look at the final order post-remand by this court for purposes of establishing a basis for the ruling, in paragraph 8, the court said, referring to the motion to vacate that was filed the day after the sale, the judge wrote, the case had been pending for 523 days. The court finds that the motion fails to state a legal basis on which to grant relief or intelligently exercise discretion. The court denied the motion on July 21st, 2009 using a stamp. I would respectfully suggest that the fact that the 523 days, that does not constitute any grounds for denying the motion to vacate the sale that specifically identified that the parties were attempting to amicably resolve the case.
Well, trial judges have standards. And the Supreme Court says that trial judges are supposed to resolve civil matters within 180 days from filing to conclusion. So I think the time is relevant. But be that as it may, your time has expired, and we appreciate the argument.
Thank you, Your Honor.
All right, we'll call our